Even though the second property was mentioned in the termination agreement, a listing agreement should have been executed on the second property if the broker wanted to receive commission for the transaction. However, it is unlikely the broker would have been entitled to a commission on a canceled contract. Remember, the theory applied to commissions is they are due once a ready, willing, and able buyer is found. Clearly, this buyer was not ready, willing, and able because they canceled the contract. Stearns versus McGuire, 154 Fed, APPX.70, 2005. This case was appealed to the U.S. Court of Appeals for the 10th Circuit. Utah does fall under the jurisdiction of the 10th Circuit. However, this case was originated in Colorado and was based on Colorado law. From Chapter 1, remember that Colorado law does allow transaction brokers. Some buyers engage the services of a real estate broker. Stearns, in order to find an investment property with a purchase price in the range of $1 million to $1.6 million. Stearns contracted McGuire, who owned an apartment building in Boulder, Colorado. McGuire was an attorney, but was not represented by a real estate broker. Stearns prepared an offer on behalf of his clients and presented it to McGuire. McGuire prepared a counteroffer which increased the purchase price and allowed for the payment of a commission to Stearns. The buyers accepted the counteroffer and Stearns. McGuire later discovered that Stearns had failed to disclose material information to him regarding the Boulder real estate market. Stearns had also failed to disclose that he was friends with the buyer. McGuire demanded additional payment for some expenses from the buyer. The buyers ultimately canceled the contract and the transaction did not close. Stearns sued McGuire for the commission on the transaction. McGuire countersued, alleging, among other arguments, that Stearns had breached a fiduciary duty owed to McGuire. McGuire basically asserted that Stearns would have been acting as the seller's agent rather than the buyer's. The court trial ruled in favor of Stearns, stating that there was no written agency agreement between Stearns and McGuire. Since there was no written agency agreement between the parties, Stearns owed no fiduciary duty to McGuire. According to Colorado law, Stearns was only acting as a transactional broker. McGuire appealed, asserting that the purchase contract wherein he agreed to pay Stearns a commission and which was signed by Stearns constituted a written agency agreement. The appellate court did not agree with McGuire and affirmed the decision of the lower court. The appellate court stated that the real estate contract between the parties was not sufficient to establish an agency relationship between Stearns and McGuire. The purchase agreement did not contain any verbiage wherein McGuire consented to the agency relationship, and nothing between the parties suggested McGuire had ever authorized Stearns to act on his behalf. As we mentioned previously, decisions by the 10th Circuit are binding in Utah. However, this decision is based on Colorado law, which allows transaction brokers. Remember, Utah law requires full representation if an exclusive brokerage agreement is used. The theories expounded by the court are relevant to Utah licensees because they apply to the formation of an agency relationship. Utah law requires a written agency relationship between the broker and the client before a contract is signed, which binds the client. The court was very clear in that case that the written agreement needs to be an agency agreement and needs to define the relationship between the parties. The purchase contract, which provides for the payment of commissions, could have been viewed as evidence of an agency relationship. However, the court seemed to demand an actual written agency agreement rather than just evidence of an agreement. It is interesting also that the court cited the fact that McGuire never authorized Stearns to act on his behalf as evidence that an agency agreement did not exist. The lesson from this case is simple. Agency agreements need to be in writing, or they may not be enforceable. Courts may not always rule in the manner this court ruled. However, this court was clearly looking for a written agency agreement before they would enforce any sort of agency relationship. Moody Realty versus Hustis, 2007 Tennessee APP Lexus 191. The facts surrounding this case occurred in Tennessee. The Hustises engaged the services of Moody Realty in purchasing a dairy farm. Agents for Moody Realty prepared the buyer agency agreement as required by Tennessee law.